Hello, everyone. I'm Bob Seeman, and this panel is on cyber law and arbitration, and we have a wonderful selection of highly skilled lawyers. And of course, because highly skilled lawyers love talking, it's my job here today to keep them on time. So let's get right at it so we can fit in as much as possible within this hour for this panel. So everyone has 30 seconds max to introduce themselves. Go ahead, speed talk. Robert, Carolina.
Hi, Bob. Thanks very much. I'm Rob Carolina. I've been living and working in London, England for nearly 30 years now, where I practice law and I teach legal and regulatory aspects of cybersecurity at Royal Holloway University of London.
Fantastic. Alex Urbelis.
Fantastic. I'm Alex Urbelis. I'm a partner in a Blackstone Law Group in New York. I started out in information security a long time ago as a teenage hacker. And according to many, I went from bad to worse when I became a lawyer. Since then, I've worked at CIA, the U.S. Court of Appeals for the Armed Forces, Steptoe & Johnson. I was Chief Compliance Officer of Richmond in London as well, and was also recently acting Chief Information Security Officer of the NFL.
Fantastic. Just barely made the 30 seconds there. Sean. Sean Tuma.
Sean Tuma. I am a cybersecurity and data privacy attorney at Spencer Fane I'm in our Plano, Texas office. And I'm co-chair of our cybersecurity and data privacy practice group. And typically, I would be very proud to say I've been practicing in cyber law for over 20 years. But coming up after me is Peter Vogel, so that's not going to carry quite the weight. But I do practice in incident response and crisis management, which is about 90% of my practice.
Super. Thanks, Sean. And Peter Vogel.
Thank you, Sean. I'm not quite sure what to make of that comment, but really old. I've been in cyber and IT my entire career, actually, in spite of the fact that I'm a lawyer with this group. Before I studied law, I had a career as a computer programmer and have a master's in computer science. And my law practice at Foley and Lardner is limited to representing buyers and sellers of information technology and internet services. Half of what I do is trial when things go badly, and the other half is negotiating contracts. So the point that Sean made, I think we had the same conversation last year, was I got involved with cyber so many years ago, it didn't have a name. And it was sort of like, okay, just the computer's not working anymore and it's dark, or somebody wants a ransomware or something. But we didn't have labels with it. I'm not sure that's good or bad, but I'm glad to be part of this panel. This is going to be an exciting discussion.
And we are glad that you're involved too. And Linda Klein, please.
Hi, I'm Linda Klein from Atlanta, Georgia, where I'm senior managing shareholder at the Atlanta office of Baker Donaldson. I served as the first woman president of the State Bar of Georgia and as president of the American Bar Association, which is a worldwide professional association where access to justice issues are central to our work. My practice involves efficiently resolving disputes between businesses, often using voluntary dispute resolution, usually mediation, arbitration, instead of courts. I also serve as a neutral, either mediator or arbitrator, helping other lawyers, business clients, with their disputes.
Thank you, Linda. So, Robert, you are going to now set the stage, and I am marking down the time of starting right now. Go ahead, sir.
Not a problem. So it's 10 minutes to just say whatever comes off the top of my head. Is that it? Marvelous. Yeah. I love challenges like that. One of the advantages of being a part-time academic, which is, I suppose, another way of saying a pseudo-academic, is I get to spend time trying to figure out what I think are the things that people working in cybersecurity should be most concerned about. And given the multinational catchment area of our student base, I have quite a broad constituency I have to talk to. So I have 5 different areas that I want to highlight that I'm seeing as, I guess, mega trends or meta trends or international trends. The first of these is what I would call the increasing focus upon increasing awareness of what people are calling digital sovereignty. And as a broad perspective, I would describe this as the extension of sovereign jurisdiction into cyberspace and the slow dawning in the common imagination that the internet is far from borderless. While the internet may be distance-less, it is border full. And so we see evidence of that in a lot of places, but a couple that I'll give you that you're probably very familiar with. Obviously, the Microsoft case recently and the emergence of the Cloud Act in the US, which is really just a retelling of the same story that happened with SWIFT between 2004 and 2006, which many of us will remember. And we get rumors of those of us who work outside government service, get rumors of various law enforcement.
Can I just stop there? Some of the audience may not know about the SWIFT case.
Sure. Oh, the SWIFT case. That's an easy one. It's like Microsoft, only different. An arm of the federal government, we don't know who, knocked on the door of SWIFT offices in, we think, New York, and said, we want a copy of all transactions coming from or going to people on this list of 5,000 or 10,000 folks. The folks in SWIFT US said, we don't think we can do that because that might be violating the law of Belgium or the law of the European Union or someplace else. And the US federal agent said, you don't understand. I have a badge. I have a gun. You're in the US. The records are under your control. Give them to me. Which point SWIFT US said, oh, thank you for explaining it that way. And they gave over the information. And they were not allowed to tip off their headquarters in Law Belgium because that would have been against the law since it's a covert operation. Eventually, news of that story leaked out, and that's why I know about it. And it became a diplomatic incident. And there was a diplomatic resolution. And that's how we ended up with a data sharing agreement with the European Union about financing of terrorism. So it's not that different on a factual basis from what happened with the Microsoft warrant case, where the government, again, went to a third party and said, give us information. They said, we store it in Dublin. They said, we don't care where you store it. It's under your control, so give it to us. The US is not the only sovereign around the world playing this particular game. I would go so far as to say just about every sovereign state with the capability is going to exercise their jurisdiction over persons who are within their control. And so that is a meta trend that I see emerging significantly. Area number 2. Bob, if I go over time, it's your fault. Area number 2. Emerging understanding of responsibility and liability under data protection and related laws. The news here in the UK, of course, is that British Airways was only fined 20 million British pounds, roughly US $26 million, as a result of their data breach event. Now, the officials were going to fine them closer to 200 million pounds. And in their finding note, they said, well, we're going to reduce that, among other reasons, because we know how badly you've been hit financially by the pandemic. So data protection has gone from being a slightly nerdy, nobody cares area, which is what was happening here 28 years ago when I started practice, and has now turned into an, oh my God, this is a category 1 risk that boards need to look at. And it's not just GDPR and what will soon be known as UK GDPR where I live. Also, we see California deciding to step into the frame, and a lot of us are waiting to see how that's going to play out. And in this area as well, within the UK, I've alluded to it once, and it'll come up again maybe, is that, it's Brexit. Oh my, oh my. At 11 p.m. on December the 31st, we are in the UK are due to be completely out of the European legal regime, but the UK will continue GDPR under something we call UK GDPR, which is almost identical, except that it'll be under the sovereign control of Parliament. And everyone's waiting to see what this is going to do to transnational data flows, because the European Union has not yet given a decision allowing us to participate in the Data Protection Club, and there's lots and lots of negotiation going on. We might touch on that if someone has a question. Area number 3, what I would describe as the slow emergence of legal standards in the field of cybersecurity, and the understanding that cybersecurity involves not just obligations to your own organization, but obligations to others, obligations to third parties. As we get more experience with cybersecurity, practitioners are beginning to understand that their failures might result in harm to third parties, harm to victims, whether they're customers or counterparties or people they've never met. Those harms are becoming foreseeable. As they become foreseeable, those of us who've been trained in the law will recognize that that's one of the key triggers for duty of care, which is to say negligence liability. We're also starting to see a growing body of forensic techniques available to prove how harms have been caused by cybersecurity failure. One of the reasons that people haven't worried too much about this area in the past is because it's been very difficult for people to demonstrate how someone's failure to act reasonably with cybersecurity results in a harm to them. As forensic techniques get better, that is changing. And finally, in this area, we're seeing increasing levels of harm by the emergent Internet of Things. And here we have what a colleague of mine refers to as the emergence of the killer app, death by cloud. Everything is becoming connected, and when those systems can be suborned by bad people, death can result. From something as simple or as harmless looking as a remote control thermostat. If you imagine the remote control thermostat in the home of a vulnerable individual, setting the heat too high or too low at the wrong time of year can be a deadly event for people in that kind of circumstance. And of course, everyone loves to talk about autonomous vehicles, even though nobody wants to insure them yet. Probably because people realize that when those things go wrong, that the manufacturer is going to end up strictly liable, because now we're talking about a cybersecurity failure that becomes a product defect for purposes of strict liability, at least if the accident or the incident happens in the United States or the European Union. I'm sensitive to the fact that Canada does things their own way. Area number 4. Continuing argumentation about the scope of crimes against information systems. And here I'm talking about the uncertain trigger for what do we mean by wrongful access to a computer. I'm sensitive that there are cases in the US, there's a split amongst the circuits about when do you or don't you hold someone criminally liable for intruding into a computer. Here in the UK, there's a constant bit of hand-wringing about should we or should we not revise the Computer Misuse Act 1990. And in all of these debates is one key issue. How do you tell the difference between a legitimate researcher and a criminal hacker? That is extraordinarily difficult, and not just in really weird edge cases. It's very difficult for some people to work in that space without technically violating the law, but nobody is quite sure how to modify the law to how to figure out how to segregate the good guys from the bad guys. Last point, and it's probably the furthest from what this panel will be asked to talk about. In international law, public international law, we see continuing uncertainty about the application of existing international norms, particularly to offensive cyber operations. And we see various efforts by sovereign states to continually push the envelope about how far can we go, how intrusive can we be before we break over from being simply criminal to actually activating instruments of international agreement and violating international norms about not starting wars. So that's the world as I see it, Bob.
Robert, that was fantastic. And despite my question, you're 2 minutes under. So let me ask you a question about the wonderful chapter, the CyBOC chapter that you co-wrote and have placed in the materials for the conference attendees, which I distribute not just to non-lawyers, but to lawyers to learn about this area. But you say the juicy bits are in the footnotes. Give us a juicy bit.
Well, the cybersecurity body of knowledge was a project commissioned by the UK government, and it's a gift to the world. It's about 850 pages in total, and I wrote about 112 of them, specifically to do with law and regulation. There are 18 other knowledge areas that have nothing to do with law and regulation, so mine's a little bit unusual. And you're right, the fun is in the footnotes. So, for example, in footnote 8, I say, please don't ignore the footnotes because that's what's important. So hopefully people read those. Similarly, I have a very long footnote about Lawrence Lessig's commentary about code is law. So unfortunately, a lot of people who work in cybersecurity have looked at that phrase and say, oh, code is law. That means that since I'm writing the code, that's what the law is going to be. Well, I think there's a bit of misunderstanding about the direction of causality in terms of not so the people who write the code are not necessarily the people creating the norms. And I think that that's starting to sink in. In fact, I've heard Bruce Schneier talk about something similar recently where he says, he said on a great quote, he said, the problems we have with privacy, the problems we have, we can't solve them with technology. We can't blockchain our way out of this. And I said, as soon as I heard him say that, I said, I'm having that. I'm going to use that again.
That's super. We cannot blockchain ourselves out of this. Alex, thank you, Robert. That was wonderful. Alex Herbelis, I'm sure we're in for some entertaining stories from you. Oh, you're on mute.
Always, that's one for the card today, I guess. Yeah. Following up on what Robert had mentioned too, in terms of public international law, and if I go over, it's Robert's fault now. I think just yesterday or the day before, Oxford came out with a statement on international law protections against electoral interference, which I think is highly relevant. And one of my former professors at Oxford, Dapo Akande, was one of the authors of that. And so I definitely see some really interesting developments there. Some of the stuff that I want to talk about specifically, shifting gears a bit, is a cybersecurity blind spot. And this will be of interest, I think, to some of the more technical folks in our audience today. And that blind spot is the DNS, the domain name system. I want to talk about some of the really nasty stuff that I'm seeing, some of the groups that we're tracking, and how legal and security teams can work together to reduce this type of risk. Now, the DNS, the domain name system, as we all know, has been a critical component of the internet, but it's also infrastructure that has been subject to decades, literally decades of abusive conduct. And I'm talking about cyber squatting, typo squatting, permutations of domains. Almost 21 years ago, the WWF, the World Wrestling Federation, not the World Wildlife Federation, filed the first UDRP. And I know Bob's going to stop me and say nobody knows what a UDRP is. UDRP stands for the Uniform Domain Name Resolution Policy. It's an abbreviated arbitration to reclaim a domain name from a cyber squatter. And today, we see threat actors using the DNS for very highly sophisticated cyber attacks. Now, in the meantime, DNS enforcement, taking the form generally of brand protection, has become a game of whack-a-mole. And because of that, a lot of companies, a lot of big organizations have thrown their hands up and said they just can't do it anymore. It's too expensive, too many resources, too much activity to track. Now, if you think about the DNS like a garden, and I like to think of it that way, and that weeds will grow in an unattended garden. And if you leave a garden to become completely overgrown, you might find one day that you have snakes in that garden. And that's the situation I feel that we are in right now. We cannot afford to ignore risk coming from the DNS any longer. And to make matters worse, and here's where the legal and security component come in, it's become a major blind spot for a lot of organizations. And this is precisely because the DNS presents a problem of a hybrid nature. On the one hand, the DNS is a legal problem with security implications, and on the other hand, it's a security problem with legal implications. So in a lot of organizations, no one actually has or wants ownership of this particular risk. And so the problem festers and the snakes get bigger and more nasty. And unfortunately, because emanating from the DNS is a great deal of risk, and addressing that risk collaboratively between the legal department and the security department and security operations in general it's a great way that is often missed to build bridges and trust between two different departments, legal and security. They have to act symbiotically today, otherwise things are going to fail. And now on to what we're seeing, both old and new. We're still seeing a lot of phishing attacks from typo squatted domain names, but that's not where the real threats are coming from. The truly nasty stuff is below the surface of the DNS in the world of subdomains, or DNS-A records for the more technical folks out there in the audience. In fact, it was a GRU, a Russian intelligence spear phishing attack in 2016 that actually compromised John Podesta and the DCCC using a subdomain that replicating a Gmail login portal. And I want to illustrate why subdomains are important and used by sophisticated threat actors, and especially state-sponsored threat actors. And Bob gave us a prohibition on slides, but he didn't give us a prohibition on props. So I want to show you a domain name, com-auth2-session-login.email. .email is a new GTLD, a new generic top-level domain in which you can make a domain name registration. That's, let's say, this is all hypothetical, by the way. This is a hypothetical domain name that anybody can create. Now, a subdomain on top of that is what's to the left of that particular domain. And you can create anything you want in an unregulated fashion. So with one DNS-A record, we can create something that looks like this. Again, hypothetical, boeing.com-auth2-session-login.email. That subdomain is a DNS-A record. That's really scary because the URL looks like boeing.com. And exactly what we teach our users to be wary of. Things don't start or end with boeing.com. Look for boeing.com. If it's not boeing.com, don't click on it. So using DNS-A records and subdomains in this way is exploiting the very type of training that we're giving our users. It's really interesting, the kinds of sophisticated activity. So obviously, this can fool even sophisticated and tech-savvy users. And unlike domain names, going back to the legal side, domain names have several IP enforcement mechanisms available, like the UDRP that we mentioned. URS is another one. There is no legal mechanism to swiftly remove a subdomain. Now, I want to discuss three examples, hopefully I've got some time here, of nasty stuff that we've been seeing. back in 2018, a healthcare client of ours for which we perform DNS monitoring, and we're helping out at the time, was targeted by a really sophisticated state actor right in the wake of a merger. And this was a bogus employee satisfaction survey, and the attack existed entirely in subdomain space. We tracked this threat actor. We are continuing to track them now. It was one hacked domain and one subdomain. We're now tracking 751 domains belonging to the state actor. They've targeted over 1,700 companies in the United States, United Kingdom, Canada, and Australia, the vast majority of which are in the United States and involved in critical infrastructure. I'm talking about pharmaceutical companies, chemical manufacturers, heavy industry, defense contractors. Even the food distribution ecosystem in the United States was targeted by this group. Another very high profile group that we were tracking has been attributed to a group known as Dark Hotel. That was not our attribution, but we were tracking this group. They were targeting a large amount of international organizations. And in the middle of May, right when things were really starting to kick off with the coronavirus, and there was a lot of hysteria about COVID-19, that was when we found a state-sponsored attack from this group on the World Health Organization. And we're able to relay that intelligence over in a timely fashion. Another group that we've been tracking really recently within the last month or two, and we're only monitoring, I would say, about 15 to 20 domains of their infrastructure right now, is targeting exclusively media companies. I'm talking about film companies, production companies, PR companies, and targeting and retargeting very persistently. It's certainly a really sophisticated threat actor. We believe it's a state. We don't have a lot of attribution detail yet. But again, these are all attacks that are existing on top of generic domains, like I showed in that particular example, but are using subdomains to target these particular companies. So the takeaway here is that you cannot rely on brand protection for information security. That's a tool that's ill-fitted for its purpose. It's like trying to jack up a car with a crowbar. It's just not going to work, and you might get hurt. What we've developed within our firm is a very unique and powerful way to scour the DNS, the whole globe, including subdomains, to find these early stage indicators of cyber attacks. Now, we don't recommend continuing to play whack-a-mole with the DNS. What we've developed are some better and smarter ways to identify and then neutralize these sophisticated risks originating in the DNS by looking at the DNS differently. In fact, by looking at the DNS from the perspective of an attacker, not just a defender, is how we do this. And when legal and security work together, which is what we want to facilitate, the result can quite frankly be a case study about how proactive and multidisciplinary cybersecurity can reduce risk and eliminate blind spots. That's what I've got.
Fantastic, Alex. And you are ahead of time too. You're 2 minutes ahead of time. So let me ask you a question. There's something going on in the United States right now, which is getting a lot of global attention and United States attention. Do you see anything going on vis-a-vis the US 2020 election, either internally from the United States or, of course, from foreign actors?
Yes, as a matter of fact. And in fact, we have been tracking voting related domains and Trump domains and Biden domains and a lot of other election related domains and subdomains for quite some time. In fact, we've been tracking election related domains since before the 2016 election. I can't go into a lot about what we're seeing because of some client confidentiality, but we have seen a very significant amount of targeting of US voters. And what we would say is election interference that crosses over with financial fraud. So it's some of the more interesting types of fraud that we are seeing today. And we're also seeing a lot of things cropping up on the misinformation front, especially in the wake of the debates. When the president had mentioned, the Proud Boys should stand back and stand by. Well, you can imagine the DNS went crazy within the next 12 hours. We started seeing a lot of very interesting registrations. We're monitoring a lot of stuff for misinformation as well as continued financial fraud.
Great. Thanks, Alex. That was a great overview of, and some very, very interesting insight. Sean, now you're up. Please educate us.
Bob, thank you. Alex, great stuff there. I appreciate the opportunity to speak here. As I mentioned in my introduction, I work in incident response. That's what my practice revolves around, incident response and crisis management. what is often known as a breach counsel, breach coach, privacy counsel, breach quarterback, whatever other term they're going to come up with next week. Our goal is to come in and basically, when a company has a significant cyber incident, come in and serve as their head coach, if you will, guiding them through that process, addressing not only the technical aspects and kind of leading the team in that regard, but also the legal and the regulatory impact of what's going on, determining whether that incident is in fact a data breach or not, that would require reporting and disclosing and notification and all of those things. And another thing we do a lot of that people don't realize is serve as a counselor, not a legal counselor, a counselor of just saying, look, folks, we recognize this is a difficult time. You're under a lot of stress. You're not necessarily making wise decisions because of the stress and the pressure. We're here to counsel you to know your life is going to be okay. We're going to, get this under control. And so the reason I say that is because these days, I'm sure, we've probably heard the term ransomware, right? Everybody's heard the term ransomware. That's really what my life consists of now, is ransomware day in, day out, and dealing with those cases. And, I had a client yesterday just literally breaking down because of the pressure and the stress that came about from having their healthcare practice hit with this. Had another client recently who said, Sean, I feel like I've aged 10 years in 1 week dealing with this event. And you can't tell someone what it's going to be like until they're actually in it and feeling the pressure of it. And it's a shame because a lot of folks think they're immune from this. They think, we've got a good IT department, we've got a good security department, we have a managed service provider, whatever. We're seeing all of these get hit. So there is no such thing as being immune from this anymore. And we're seeing, very large, very sophisticated companies get hit, large managed service providers that are very technically sound. It just shows the impossibility of security right now because you've got to get it right 100% of the time with security, and a bad guy only needs one lucky shot. And there you go, you're in that position. And so one of the things I really want to talk about is something we see that creates problems for companies in dealing with this on a regular basis. And if you can see the bags under my eyes right now, it's because we are in the midst of a very difficult ransom negotiation process that has not gone the way we would like for it to. And that means around the clock, texting, phone calls, all of that good stuff. It's happening right now as we're sitting here. And one of the things that we see regularly delay and cause problems in this response process is companies not being prepared for a real world incident response. And we hear a lot of talk about incident response plans and incident response planning and tabletops and all that. And they're all fabulous. And I encourage every bit of it. But at some point, you've also got to have a very simple plan, not that big binder of materials that's documented and looks impressive to the board and the regulators, but really a one-page action item that identifies, when do we need to respond? When do we need to engage? Who do we need to help us? What do they need to do? How do we need to reach them? And who's going to handle what as far as communications go? And are these people approved by our insurance carrier? Because that is a critical problem right now that we're seeing that's causing a lot of delays. And if somebody has that right there sketched out on a whiteboard and they take a picture of it with their cell phone, that's going to get them a lot farther than a lot of these really complicated plans will in a real world cyber incident response. And so I'll just tell you a story of a particular 24-hour period that's happened within the last month, where a new client comes to us, their healthcare, they get hit with ransomware, patient treatment, all operations are shut down. And it comes in on an evening and they're like, hey, we need to get to work. What are we going to do? And so we tell them, well, you've got to have a forensics and a decryption vendor, because unfortunately their backups were taken out by the threat actor. There was no opportunity to recover from that. And we're going to have to get together and we're going to have to negotiate this ransom, and we're going to have to deal with it, because that's your only hope of getting back restored operating and treating patients. And so then they tell us, well, we already have a vendor and we really like them and we want to use them. It's not someone I'd worked with. It's not someone the insurance carrier had worked with. And so we then lose 24 hours trying to get that vendor approved to even do the work, because they were not approved under this client's insurance policy. So the client had to make a choice. Do I pay out of pocket and forego my insurance coverage, or do I handle getting this vendor approved? We took the delay, got the vendor approved. Then we get started with the process. It appeared that the vendor was not very good at the negotiating. They didn't have the connections, the resources. We did finally reach a point where it looked like we could then make a payment. The threat actor proved they could decrypt the non-sensitive files. And then we're like, okay, make the payment. You've got approval. Well, then they didn't have the resources to make the payment, because due to recent OFAC activity, which is Office of Foreign Asset Controls, that's put out by the U.S. Department of Treasury. There's been a lot of activity in this area in the last few weeks. A lot of vendors who would typically facilitate these payments are now stopping making these payments. So we then reach a point where we've got to go through another 24-hour period to find a vendor that would work with this company to help facilitate the payment and get the decryptor. And, the problem here is all of this stuff could have been resolved ahead of time. All of the delays, all of the problems could have been resolved in advance if the client had sat down before this incident happened and thought, okay, who's going to be my legal counsel? Who's going to be my breach counsel? Who's going to be my vendor for forensics? Who's going to be my vendor for decryption if we ever need it? Who's going to be my PR firm? All of these things, and then go to the insurance carrier and say, I want to get this team added to my policy as pre-approved. And you can either get them approved, or if you can't under certain policies, you can then find out who are the carrier's list of approved providers and develop a relationship with them in advance. Had that happen here on day one, that ransom would have likely been negotiated and paid within 12 hours after our getting engaged on that. Instead, they lost several days, which then put it into a weekend, which made it much more difficult to get approvals, which then put it into the following week. And ultimately, they lost about a week of operations because they did not go through the process of understanding, did they have cyber insurance? If so, who's on the team, who's able to play, putting a plan together that takes that into account, and a plan that's very practical and very simple as far as when this happens, what do I need to do? Who do I need to call? How do I reach them? Who's going to be responsible for what? And are they approved? So it's just a problem that we're seeing over and over. And I really cannot encourage strongly enough companies to take this seriously, plan ahead for this, and get all these details worked out ahead of time. Bob, I'm not sure how much time I have left.
You're right on time.
I'm only halfway through, man.
No, keep talking, because I'm not going to sleep tonight. So keep talking. I need to know what my nightmares have to be.
That's right. You have brought home the reality of ransomware. This is really the first time for me, and I think for many people listening, that hearing from somebody who deals with
it's going on right here as I'm
game.
looking down on my phone from time to time. The negotiation, the struggle of the panic of the providers, the healthcare provider in this case, the uncertainty, because now what worked well a month ago because of recent activity by the U.S. government to clamp down on paying and funding terrorism, which we all recognize is an incredibly important issue, but it's having the practical effect now of making it much more difficult to get a negotiation, to get it paid, to get clients back in operations. And ultimately that impacts patients. And, I'm sure many have heard about the story in Germany recently of a patient who died because of that. And it's just it's a tragic situation, and something that planning ahead look, the problem is security, right? If we could improve security and if we could get backups at a point where they would be safe and secure, then you just you kick the bad guys out, you secure your network, and you restore from backups. The problem is we're not there yet. And so that's why we're seeing all these problems.
Yeah. If I could jump in just further to Sean's point there, something that I mentioned during my spiel was the targeting of 1,700 entities across the United States of a group of threat actors that we've been tracking for over 2 years now. The sector that was targeted the most, that has over 300 targets in it from these guys, is the healthcare sector. And it makes you wonder, what kind of controls and processes were in place to stop this. We couldn't get to everybody in time when we were seeing these. And so now you have this pre-existing access from perhaps one or maybe several groups of threat actors that could result in the exploitation of that access in a ransomware event. So it's not even new attacks that are happening, but it could be new exploitations, and then capitalizing on the very legal issues like those stemming from OFAC that Sean had mentioned to make this more costly and more difficult for the targeted victims.
Yeah, and to pick up on that point, Alex, last evening, yesterday the FBI held a press conference talking about this threat on healthcare from ransomware, which is pretty rare to see a conference like that. And then last evening, I know the Dallas FBI put out a bulletin on this that was marked white for free and open distribution. So definitely look that up, because if this is pertinent to your industry, there's a lot of helpful information in there.
Wonderful, Sean. That's fantastic. Peter, please, the stage is yours.
Well, I think I've changed my mind about what I'm going to talk about today because of all the comments everybody's made. But let me share one more thing about my background and perspective. And Sean and I have been friends now for more than 20 years. And where we connected, and this is kind of back to one of the points I think that Alex made, and that is Y2K. We were watching for the world to fall apart in the year 2000. I think I gave 35 speeches in 1999, and that's where Sean and I met. So this is the whole concept of the vulnerability is not new. But I'm going to say this in another perspective. I've been an adjunct law professor here in Dallas at SMU for 30 years. And for 15 years, I taught a course on law of e-commerce. And so I've been watching this. So the DNS issue is, actually, Alex, I'm glad you spent so much time on that, because I think most people have no idea what the DNS is all about. And a few years ago, one of my good friends, one of the major, had a bad day because their DNS server got taken down. And you can imagine a whole bank not having DNS server. It's pretty devastating. And I think the reality of this, and I'll say it in kind of the best way possible to our audience, as I pointed out earlier, I've got a master's in computer science. And one of the real problems we have is anybody that's any good with a computer is incapable of having a meaningful relation with another human. And I kind of mean that. I know Sean's heard me say that a million times. But the reason I say that and why that's so important to the discussion today is that technology people do not speak in plain language. And so they can't communicate effectively to the board or to the C-level people that need to take action. And I think that's one of the reasons Sean feels that kind of pressure that people don't seem to take it seriously, because the technology people, those of us who, spent careers as programmers or whatever, we use gizmo head language, and that's a big mistake. And it kind of brings home an issue. A few years ago, I did a program with one of the cyber insurance carriers, and they told us an interesting story. They said, before they make an offer to a new cyber insured company, the first thing they do is interview the board. The less the board knows, the higher the premiums. So it's just kind of the reality of where we are today. And I think the importance of a number of these issues that have come up today, but in healthcare, because I've been in the healthcare industry my entire practice, is one of the reasons is that data can be sold in the the dark web, and it's got great value because in the US, Social Security numbers, they don't expire, and we have all these problems with the data. And another important issue, I think, associated with the ransomware, because this has just been a huge issue. About a year ago, I had a client who was in the business of paying ransomware. They're an international company, and that's what they do, is pay ransomware. Well, some cyber criminals hijacked the comptroller's email account and changed the address of where the ransomware was going to be paid. They thought they were paying the ransomware to one criminal, and it went to the wrong criminal. And then they didn't have enough Bitcoin over the weekend to make that happen. And now back to the kind of insurance issue that goes along with this that I think is really important. That is, I've defended insurance companies over the years, particularly with important complex IT contracts. And one of the realities of the cyber world is the criminals are smarter than they think we think they are. And whatever worked last week, they're not going to do that again. They're going to come up with something new and clever, and it's going to be different next week. And so you try and have an insurance policy predicting what's going to happen next week, and that's not going to happen. So the insurance companies are in a position where, and I don't begrudge them this, they don't want to pay off on these policies if they could avoid it. And we know that with insurance anyway. There's no history about the cyber world that is long enough in the making so that the cyber insurance is protected. So another important issue, and I think Sean just made this point, is Alex reaffirmed about the Department of the Treasury. Just for the sake of clarity for the audience, I mean, we know what that's about, but the government is threatening to sanction companies that pay ransomware. Now, it's a threat so far, but if that goes into effect, that's going to have a chilling impact on whether or not it makes any sense to try and get your data back, have it unencrypted, pay ransom, or what. This remains to be seen, but I think it's a really critical issue. And then finally, I guess the last topic I wanted to talk about today that I think is really critical is the Internet of Things. Robert brought that up, and I think Alex, somebody else already talked about that as well. Right this minute, the expectation is, the estimates are, there are going to be over 31 billion things connected to the internet by the end of 2020. And if you think about the risk and the vulnerability, there are really no laws anywhere in the world that are designed to protect the Internet of Things. And yet they're everywhere, and it's not diminishing. It's supposed to be increasing, by the billions in the next few years as well. So those are my comments. I hope I didn't go over on that either, Bob. You'll let us know.
No, you got plenty of time. You were great. You were talking about how cyber insurance companies, not to use exactly your words, don't necessarily like to provide coverage in certain circumstances. In those circumstances, when it's an issue of coverage, is arbitration a good idea?
I think it is. And the primary was, in today's world, we are not looking at everything happening in one country. And the court system in the US is one thing. But outside of the United States, I think the way litigation is resolved is through the arbitration process. I've been an arbiter myself for more than 30 years and had many international cases that get resolved. And I would be very, and when I have litigation in courts like in France or Germany or something, the predictability of the courts is very different. And the predictability of the arbitration process is much more reliable. So I do think it's important to devote that. And I know Linda's going to spend some time talking about that as well. But I do think that if you have a policy complaint and it's supposed to be resolved by some court in another country, those of us who've been in international litigation for years know that's not the way to resolve it. You need an arbiter to try and help work that out.
Great, Peter. Another question is, Robert mentioned all the privacy laws that are coming into place, and a practical question with all these new states and other jurisdictions coming into place, from a practical perspective, how can online companies keep up to date?
Well, that's a great question, because for the past 25 years, I've been writing terms of service, privacy policy, and click agreements. And frankly, nobody reads them. I mean, I've taken a show of hand as I travel around the country. I'd say less than 1% of the population changes, reads them. But one of the problems that I have in terms of service and all is oftentimes they do not apply to the business. Or if there's a California Consumer Privacy Act applicability, I have a client, I'm obviously not going to name names, but I have a client that we started talking about California Consumer Privacy Act. They're still not updated their privacy policies. We sit here today and it's almost 2021. There's a risk associated with that. And I think all of us that follow the privacy laws know that. Plus, we have expectations in the state of Texas. Our legislature is planning to have a similar law. Other states are down that road. I think New York is considering one now, Massachusetts as well. And if we have 50 separate privacy laws that interact in different directions, it causes a huge problem in trying to enforce them around the United States, let alone GDPR, which theoretically applies to EU citizens in the US. But I had a client who has, or I have many clients, I should say, who don't believe the courts in the United States will enforce the GDPR in the US. And frankly, I don't know a single judge in the US that would do that, because it's not US law. It is the law of the EU. And I think we haven't gotten any litigation on that yet, but when it comes, it's going to be really complicated to figure out what law applies. Internet jurisdiction is an issue of great complexity. And I think that that's a concern that we've all got too, is internet jurisdiction is a moving target. And that Cloud Act doesn't help, I think, because that hasn't been tested in court either.
Fascinating. Thank you, Peter. Linda will now give us a bigger picture, not to focus necessarily on cyber law, about mediation and arbitration generally. Yeah. Linda Klein, please.
Well, thank you. And all I can say is, wow, I have learned a lot. And I said before that I'm not going to sleep tonight. I think that's probably accurate. I'm not going to sleep tonight after all I've learned. But I'm going to bring everybody down to basics. This is not the gizmo head portion of our presentation. I hope to give you some very practical knowledge about solving business disputes. This is not going to help you much when you're dealing with cyber criminals, of course, but may well help you when you're working on disputes with vendors and with others. When I first started practicing law, almost every business dispute that wasn't resolved by negotiation was resolved in a courtroom. And today, most disputes are still resolved by negotiation between businesses and without lawyers. However, when negotiation does not settle things, we have the option of using any number of types of alternative dispute resolution instead of going to court. Unless your contract requires alternative dispute resolution, and let's just call it ADR from here on. So unless your contract requires ADR, your dispute will likely wind up in litigation. Litigation means that if you cannot settle your case, it goes to court. Why? Because if you wait until after your dispute arises, one side or the other is going to see an advantage to litigation based on the circumstances and refuse to participate in ADR. So the first thing that you always got to remember is to write ADR into your contract. And if we have time, we'll come back to this. So let's rewind the tape. Why would you want to use ADR instead of litigation? Well, ADR is almost always cheaper than trial. ADR, and we'll talk about some of the types of ADR later, allows you to limit expensive activities that are unique to court, For example, something called discovery. That means depositions, sworn testimony taken from witnesses to learn what they know. And paper discovery, interrogatories, which are written questions and answers, requests to produce documents. All of that can be limited to a more cost-effective amount in ADR. A lot of technology companies are growing fast and they're short on cash. There's no time for litigation. Disputes need to be resolved quickly. There isn't a budget for litigation. So ADR is the cheaper way to go. Next, using ADR, you're not going to have your case decided by jurors who do not know you, do not know your type of business, do not want to be there, but they got a subpoena to be there and they're very unhappy about it. And a lawyer friend told them that if they didn't obey the subpoena, they could get arrested for not showing up for jury duty. So even if you have a trial with just a judge and a jury, the judge won't know much about your business either. In ADR, you can choose who resolves your case, and you can choose an expert in your field. In ADR, you can choose the date and the time and the place you want to resolve the dispute. In court, you usually appear on a calendar and you wait your turn. Often you and your lawyers have to get ready for trial several times over several months, and then you don't get reached. And when it's your turn, you have to drop everything and run to the courthouse. And generally, it takes years to get a case to trial. And meanwhile, your business is waiting for a resolution. Now, I want to be really clear. I am not denigrating our justice system. It is like this because it is woefully underfunded. Criminal and family law matters have to come before business disputes. And in my state, the court system, the entire third branch of government, get less than 1 penny of every tax dollar. And we're not unique. And also keep in mind that the pandemic has really lengthened the time to trial even further. Now, courts were closed for months, and many of them still are. Few people have been able to find a safe way to bring back jurors. I mean, you've all seen a jury box on TV. People are sitting shoulder to shoulder, and courts they're still working it out, and funding is in short supply, and that's complicating the issues. With some rare exceptions, which are very unlikely in a business dispute, everything that happens in litigation is a public record. And ADR is generally private, and it can be strictly confidential if the parties agree. Now, if the goal is to keep business relationships intact despite having a dispute, it's much more likely with ADR because it's less formal, more cost-effective, and is generally less adversarial. So let's talk about the types of ADR. There are two basic types, voluntary and mandatory. And within these categories, your imagination is the only limit on how you can design your dispute resolution process. So let's talk about voluntary resolution. The most common form of voluntary ADR we've already discussed, and that's negotiation. And you've been doing this for years, since you were a toddler negotiating bedtime. You've been negotiating. And when negotiation fails, the most common next step is to use mediation. Mediation is a non-binding negotiation using a neutral party to help facilitate resolution. No one can force you to do anything. The parties agree on a neutral, and as a neutral myself, I can tell you it is the fastest, cheapest way to resolve a dispute short of negotiation. It's the most likely to preserve business relationships because you can settle in ways a court cannot do. A court can generally only award money. In mediation, you can settle for more services or products or software licenses instead of money. Or you can settle for a payment at a later date, or maybe a payment plan. Sometimes you can solve a problem in mediation if everyone agrees to be there, when it couldn't happen in a court because, let's say, you can't bring all the parties to the same court. For example, sometimes the parties are from different countries and you could not require them, let's say, to come to the United States to resolve the dispute. Well, think about how great it would be to have a mediation that solves a problem with multiple parties like that all at once. Again, you can be creative and think about choosing a mediator that's known to be creative. Well, what's mediation like? I'm not going to kid you. If you are a business owner in mediation, the day of the mediation, and most mediations are done in a day, but mediations, they can go on much longer if the parties are making progress. But a day of mediation can be quite boring. You'll be sitting in a room with your lawyer, sometimes for hours, while you wait for the mediator to come back to talk to you. And you have to trust that the mediator is making progress. So my advice is to bring other work to do while you wait. Choose your mediator carefully. I think it's more important for the mediator to have people skills than subject matter expertise, because the mediator has to get everyone to agree, and that involves building trust with parties in a very short period of time. Let's talk about mandatory resolution. The most common type of mandatory ADR is arbitration. And people have been talking a lot about arbitration so far today. But what arbitration is, it's like a private trial where you choose the judge, and there can be more than one. And if there's more than one, there's typically three. There are rules that govern arbitration that have been written by different organizations. The most common set of arbitration rules is maintained by the American Arbitration Association. We call that the AAA. It's not the Automobile Club. It's the American Arbitration Association. However, you can make whatever rules fit your case. You can make rules that are designed to streamline the process. But I really strongly recommend that you decide these rules in advance, not after a dispute. But most parties, they just incorporate rules already written by an organization right into their contracts. Let's talk about what you need to draft into your contract to assure that you have reserved your ability to use ADR to resolve your dispute. You can be as detailed as you want to be, so long as the parties to the contract agree. And then you can set up a procedure that suits you both. I always say that when you create a business contract, you want to plan for that business divorce. And you want to do that while you're still in the happy early stages of your relationship. And you can find standard arbitration clauses on many websites, such as the AAA's website, which is adr.org, or jamsadr.com. The most important thing is to provide for a method of choosing your arbitrators. And JAMS and AAA and other ADR providers have panels that you can choose from if there is a dispute. And I know at least the AAA has a cyber panel. I see that I'm out of time, so I guess I will just tell everyone, remember, let's save money and use ADR.
That's great, Linda. Thank you very much. I've got two questions for you. First of all, what happens if there is an arbitration agreement, the clause there, but nevertheless, you get sued in court? First question. The second question, we're all working remotely now, as we are right now. How has that affected ADR?
Well, I'll take the second one first, and that is that we're going online with ADR. I have done already arbitrations as a neutral in the cyber world, and it has been very effective. I think we got the case done much more quickly by using the internet. I will tell you that, and hopefully I haven't violated this rule myself, is when you are a party in an arbitration or a mediation that's done online, please remember to look at the camera. Look at the arbitrator. The arbitrator is your judge. The arbitrator is making the decision. Do not look down. Look at the arbitrator.
You're doing a great job. You're looking right into the camera right now.
Oh, perfect. I'm following my own rule, because I will tell you that I went through an entire arbitration. I was the only arbitrator. No one looked at me. Not the lawyers, not the witnesses. No one looked at me. It was very, very strange. And then when they went to lunch, they forgot to put the camera on mute, and I heard what they were talking about. Very, very unwise. your other question was, if you have an arbitration agreement and the other side sues you anyway, you know what? That happens pretty frequently. I'm dealing with that right now in a very large case. And what you do is you file a motion in the court that says, hey, here's our arbitration clause. And in the United States, and I think this is true in most places, arbitration, there's strong public policy that favors arbitration. In fact, last year, a unanimous U.S. Supreme Court ruled that if there's an arbitration clause, the case must go to arbitration, even if there are other people that are other parties in the case that are not involved in the arbitration. They just wait while you do your arbitration. In fact, if there's a question about whether a claim is arbitrable, that has to go to arbitration too. And in fact, I recommend that you write that into your contract, so there's no question that if one party is saying, no, the case is not subject to arbitration, and the other party says yes, that you write it into your contract, that questions of arbitrability go to the arbitrators as well.
Fantastic. Thanks, Linda. To finish things off, Robert, you started things. Finish up with some comments, perhaps about GDPR or IoT security.
You're prescient, Bob. You can read my mind. I thought that just to come back on a couple of quick thoughts, one about laws and the Internet of Things. The problem, of course, with the Internet of Things is that suppliers have always had a perverse incentive to push products into the market that are not secure. They sell, particularly in the consumer space, they sell functionality, and they view security as unwanted cost. And that's one of the biggest problems to redress. We do see the emergence of regulatory standards, and in Europe, we're now experimenting under the Cybersecurity Act with an emerging body of standards that will mandate certain minimum security thresholds for consumer items. Last comment, and this was for all of my lawyer friends especially, with respect to GDPR, because as Peter was saying, European General Data Protection Regulation applies to anyone anywhere in the world when they process data where the processing is targeted at living individuals who live in the European Union. And that vests in the hands of those millions of data subjects a right of action under tort law to take action against a controller or a processor who violates their rights. I'm waiting for the day when a clever plaintiff's lawyer in the US decides to bring a class action in a US court, and they plead the applicable law as GDPR under the conflict of law provisions of whatever state they happen to bring the case in. And given that there are 50 states plus the District of Columbia who employ, I think, 4 or 5 different theories of conflicts of law, I think an enterprising plaintiff's lawyer will find a court somewhere that will say, well, yes, under our conflict of law principles, obviously the applicable tort law will be European law because that's where the injury has taken place. So I'm waiting for that class action to emerge, and it'll be, I'm going to get my popcorn ready for when it happens.
Can I make a comment there since you brought it up? Since we are this panel, we are the lawyers, I'm assuming the audience doesn't necessarily know what a tort is. And so let me just throw this out. It's a French pastry with a lot of whipped cream on top of it. No, I'm kidding. No, actually,
made with walnuts. Made with walnuts.
Non-criminal wrong against somebody else, like fraud, trespass, those kinds of things. Point you made, but I just think the audience needs to understand what a tort is. Just thought I'd throw it in.
That was very important. Thank
Absolutely.
you. Kind of thing I should have noticed. Unfortunately, I've had a little background in law. I'd like to thank everyone for, on behalf of everyone listening, for what has had to be the best 1 hour of education about law and cyber and arbitration ever. It's been wonderful and an honor to have had this discussion with each of you. Thank you very much. And thank you.
Thanks, Bob. Thanks
for organizing all of this.
Thanks, Bob.
Okay. Bye-bye. Thank you.
Bye-bye.